Good morning. Our next case is the case number is 123590. It's in the interest of E.L., a minor child. My name is Judge Green, and I'm the presiding judge for this case. The other judges who are hearing this case this morning are Amy F. Klein and James Burgess. Let me get the appearances of the parties. Appearing for the appellant. Is this Mr. Brazel?
Still, Judge.
Okay. And appearing for the appellee.
Assistant District Attorney Julie Kuhn.
This case has been set for 15 minutes. Mr. Brazel, do you want any rebuttal time? Would you like any rebuttal time?
Yes, please, Judge. I'd reserve 3 minutes.
3 minutes. Okay. Now, are you ready to proceed with your argument, Mr. Brazel?
Yes, Judge.
Okay. Are we ready to hear it?
May it please the court. My name is Grant Brazil, and I represent the father of this child who is the appellant in this action. And at issue in this appeal, much like the argument this court just heard, involves the question of active efforts when we're looking at an Indian Child Welfare Act proceeding. This is a complicated case because it involves interstate travel, it involves the global pandemic, it involves very young parents. There are a lot of variables at play here, but the question ultimately comes down to whether or not those active efforts were made and whether or not the court at the trial level was correct in finding that those were made under a clear and convincing evidence standard. There is also an issue of the disclosure of an expert testimony of a Dr. Carrie Weeks, and I will address that if I have time, but the primary issue in this case to me is this question of active efforts under the Indian Child Welfare Act. The standard, again, is it's clear and convincing evidence. And while the Indian Child Welfare Act itself, if you look at the text of the federal legislation, doesn't have a ton of guidance as to what active efforts may be, there are some additional administrative guidance that has come out that I've relied on relatively heavily in the brief that shows or exemplifies what active efforts might be. And some of those that are relevant to this appeal are identifying appropriate services and helping parents to overcome barriers, including actively assisting the parents in obtaining such services, and identifying community resources and actively assisting the Indian child's parents in utilizing and accessing those resources. And then as to the issue of visitation, active efforts is described as making arrangements to provide interaction in the most natural setting that can ensure the Indian child's safety and supporting regular visits and trial home visits of the Indian child during any period of removal. And so I want to talk about the issue of visitation first. In this case has somewhat of a complicated factual history in terms of the placement of this child. So these parents had one prior child, D.L., the parents agreed to transfer jurisdiction to a tribal court in Oklahoma. E.L. was born subsequent, I believe, to that transfer. And when the case was filed to E.L., the parents were residing in Kansas. E.L. was brought into custody in Kansas, obviously. We came for initial adjudication in November of 2019. And at that time, the parents objected to a transfer of jurisdiction at the tribe. There's a difference. They said in D.L.'s case, we would agree. In E.L.'s case, they explicitly declined a transfer of jurisdiction to tribal court. Nevertheless, there was a regulation ICPC that was ordered, and that child was placed in the foster home, in the tribal foster home with her sibling.
But didn't the tribe intervene in the Kansas case?
The tribe did intervene in the Kansas case. They did. And they had filed at one point in the case, once COVID had kind of set in, a motion to terminate, suspend, or reduce visitation. And it's not entirely clear that that motion was actually resolved in any substantive way. The pandemic kind of forced the hand in terms of what was going on there. And there was a period of time where the tribe had essentially a travel ban and was not allowing folks onto tribal property for visitations. And in fact, St. Francis had that similar provision until about May 2020. They were not allowing in-person visitation in their office as well. But where the record develops from there is in May 2020, after St. Francis had lifted their bans, they're reaching out and trying to make monthly contacts with the tribe about when can we reinstitute in-person visitation for these folks, and don't really get a lot of an answer until September 2020, which is about 1 month prior to the termination trial, that in-person visitation can start again. And those were in-person visitations for 2 hours. In the alternative, they had remote visitations that were 30 minutes to 40 minutes in length. I think those are on a weekly basis. But at most, these folks were interacting with their child for 3.5 to 4 hours a month. And while that's not atypical of a normal sync case where folks may start on hour supervised visitation per week, when we look at the character of those visits, that's what's important. Because I understand there are limitations that happen when we have a pandemic. You can't be physically present anywhere, much like we're not physically present together today. But there was testimony of the family support worker at trial that during these virtual visitations, the foster parents were actively engaging the child in play, were kind of distracting, were preventing her from interacting with her parents. So it goes above and beyond just being an acceptable substitute. It becomes a problem when there's, I don't want to say sabotage, but for lack of a better word, that appears to be what's happening, is there's a distraction that's there.
Counsel, isn't it fair that when the parents brought that complaint to the agency's attention, that the agency stepped in? First, it was foster mom, and so then foster dad supervised the visit. And then when they had trouble with foster dad, then the agency further stepped in to make sure that that wouldn't happen. Isn't that fair?
That's fair. And that is a remedial effort that was taken. And I certainly commend the agency for that. But it's a question of at what point did those remediations occur? And it was enough to say that we really gave these folks a fair shake when we're looking at the active efforts standard. By all accounts, father was appropriate, affectionate. He was prepared during visitations with E.L. There weren't any safety concerns noted with his interactions with E.L. But looking at this issue of virtual visitation too, it was almost unanimous that virtual visitations for a 1-year-old child are a poor substitute for the real thing. Tracy Humphrey.
And I don't think anybody disagrees with that, but what did you want them to do? What would solution should the agencies, the court, whoever taken?
Under the circumstances, and I know that child time is always a consideration in these cases, we want permanency for kids as soon as we can. But under the circumstances, I think the appropriate remedy would have been to delay termination until we could truly assess whether or not these folks have been able to exhibit secondary change in their visitations. In fact, Ms. Fain, the case manager, testified that part of seeing secondary change in a parent, whether or not they've truly applied what they learned, comes in observing a parent in in-person visitations. And because those didn't start until a month prior to the termination trial, I don't know that we can really credibly get to that point, especially when father, by all accounts, is appropriate and is exhibiting reasonable parenting during those visits.
I'm going to probably throw you off track here. Father was appropriate during visits, but could you speak to what actions he took during this, with his case plan, to really address what happened to DL?
Father did have a criminal case involving DL. He accepted a plea in that case. He
took
entered
an
an altered plea. He did. Although, then this kind of dovetails into an argument that I make later, is father is not the most sophisticated party in terms of understanding what that means. And there is testimony at trial that exhibits he does have difficulty in understanding or was combative with folks about what happened with the first child initially. Now, if you look at other sections of the brief, I don't know that that testimony was most appropriate to come in through Dr. Weeks at trial anyway, but there was definitely resistance, hesitance in engaging with DL. But in terms of his ability to parent and interact with EL, a second child, there is not evidence to suggest that he was inappropriate. And while the injuries sustained by DL are a factor the court could rightfully consider, that could be evidence of his unfitness, it is not per se saying he is forever unfit by virtue of this prior case. In fact, I think at the time of EL's termination, DL's termination had not yet resolved in tribal court. And so there hadn't been a judicial determination of unfitness or something similar under tribal law.
Well, counsel, I mean, we can't just look at visitation in a vacuum. I mean, there's other requirements on his case plan in terms that he didn't complete in terms of a substance abuse evaluation. And we have a lot of, I think, dirty UAs and hair follicle tests.
Correct.
And resistance to getting drug treatment. And so while, obviously visitation is part of it, I mean, we can't just look at that alone. And what do you have to say with respect to his efforts outside of visitation to indicate secondary change when he's not completing those other aspects of the plan?
Mm-hmm. Well, as far as this is what I would maybe call more of an education gap with father. So the evidence is he's 18 years old at the time that DL came into custody, not much older at the time EL came into custody. And his extent of his education is somewhere middle of high school education, not a particular sophisticated party. And so when St. Francis would engage him and ask him about, do you understand substance abuse treatment, the importance of going to that, you have positive drug tests, they meet kind of denial, a lack of understanding. He testified at trial a couple different items about, there's no point in going to substance abuse treatment because all they're going to have me do is take a UA. There's no indication that he understands, well, hey, this is actually counseling that can help you or appreciate maybe identify triggers for your addiction and address those items. There's not an attempt to remediate that there. Another order they have folks participate in is the Wichita Area Sexual Assault Center or WASAC protective parenting course. In a case like this, where there's been physical or potentially sexual abuse against a child in other cases, he doesn't even know what WASAC means. He has no frame of reference for what that is. He testified he believes his hair follicle tests are coming back positive for methamphetamine because of a chemical in his shampoo that has meth as the prefix to it. He doesn't understand what it means to co-sign on mom's lease. And I'm not saying that
to counsel, hold on. To be fair, is it really an education gap when you're saying it's your shampoo that's causing you to come up with positive meth tests?
Folks in these cases make lots of excuses. We can call it what it is. They do. But I think if this was an isolated incident of him saying, yeah, it's my shampoo, I don't know what's going on, perhaps you have a lame excuse and nothing more. But in this case, I think it's a pattern of not really understanding what substance abuse could offer, not really understanding.
Wasn't there testimony in the record that he had some other cases where he had been required to go to substance abuse counseling? So, he's had some exposure to substance abuse evaluations and treatment outside of this particular sync proceeding, correct?
That's correct. I think that might have been pursuant to his JO case supervision as he was compliant with some orders in that case. I don't have a ton of information on the ins and outs of what those were, but I think he did have some exposure to substance abuse there. Kind of going along with this as well in terms of community resources is this question of transportation. And the 2016 guidelines that expand on the regulations that were put forward kind of offer a good example of this. They say if a parent has a problem with alcohol abuse, active efforts might include assisting the parent with enrollment in a treatment program and helping coordinate transportation to and from meetings. This father did not have a car. There's not any testimony that there was an offer to drive him to treatment, whereas Ms. Fain, the case manager, would drive him home from visitation. She did offer transportation in those instances, but when there's a crux of this, you need to be clean and sober, and we're not offering transportation in that context, that's an issue. The backdrop of all of this is, and a theme that was advanced is, shouldn't parents have to meet the state halfway? Correct, right? There should be some effort on the part of a parent, but the parent retains a fundamental right to parent his or her child. It's the state who's asking that that right be removed from that parent. That's a higher burden. I'm not going to say it's 50-50 because I don't think it is. It's the state asking to deprive a parent of a fundamental constitutional right. And there is going to have to be a higher standard, especially when we've got the Indian Child Welfare Act that's at play. Just making sure that I'm okay on time if anybody has any other questions. Okay, I think I am at about past, so I would go ahead and reserve the rest of my time for rebuttal. Thank you.
Yeah, thank you very much, Mr. Brazil. Ms. Kuhn.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. Similar to the previous case that this court heard dealing with mother, it is in this case as well, our position is that father wants this court to reweigh the evidence that was before the district court and make a finding in his favor. And as I argued previously, that is not under the purview of this court. And the district court was able to review the evidence, make credibility determinations, and this court should look at the evidence in the light most favorable to the state. It is our position that the state did present clear and convincing evidence that active efforts were expended by all the professionals to prevent the breakup of the Indian family. As previously argued, similar to mother, with father, the case manager here went over that case plan with father, explained to him the importance of completing those orders, went over a list of providers, told him about services for free or on a sliding scale, then repeatedly told father, kind of the crux of this, that he needed to get a substance abuse evaluation and address his positive hair follicle tests, emphasized to him how important this was, but he refused. Similar to mom refusing to go to therapy, father refused to address the substance abuse that clearly was going on. He would not even go get an evaluation to determine what type of treatment would have been appropriate for him. He talks about how transportation wasn't offered, but I'm not sure how you offer transportation to treatment when you have a parent who refuses to even entertain that order within a case plan. Additionally, and also this transportation question, it was not a barrier for father. We do have evidence that he did not have a vehicle, but we also know that he was able to get to employment, his job. He was able to get to visitations when they were in person. He was able to get to parenting classes. So transportation here is not the barrier that it has been argued to have been. Additionally, regarding visits, similar to mother, when this child was placed in the tribal foster home, again, had no idea what was on the horizon and that we would all be shut down. But St. Francis, when that happened, they were the ones who made the effort to have remote visits. And I do acknowledge that having a remote visit with a 1-year-old is probably absolutely not the the best way to have a visit. I mean, I can't imagine. But at the same time, we were still giving these parents weekly interactions with that child. And while you did have foster parents on the other end with that child, and maybe that's not ideal, at the same time, you can't just let a 1-year-old, have a remote visit without any supervision. There has to be someone else in that room, and it's going to be hard not to interact with them. But that doesn't mean that what was going on was not an active effort on the part of the agencies. Additionally, there was continued communication regarding when the bans were lifted, when we could get back to an in-person visit. And then when that was able to happen, it was a 2-hour a month visit with father. Also, similar to mother, the same offer was made to father. If he could have found transportation to Oklahoma, he would have been reimbursed for his travel expenses. But there was never any indication that he made that effort to find a way to get to Oklahoma to possibly have more in-person visits so that he could indeed show this secondary change that has been talked about in his visits. But the reality is here in this case, we have active efforts, but we also don't have much initiative from parents to complete those court orders, to deal with the issues in their home, to show that there's been secondary change. We cannot ignore what happened to the first child and the fact that no responsibility has ever been taken, no explanation has ever been made, and we've made no effort to show that the home would be safe for this second child. And this court, the district court, did not have to ignore what had happened and these parents' history and put that child in the home and just wait and see if it was going to be safe. We don't have indications here that it was safe when they're not addressing the issues that came into play with their first child. So we feel that the state did present clear and convincing evidence of active efforts in this case. And the professionals did go beyond what we normally look at in a sync case and did try to help father get services, stay engaged with his child, all of those things. But while it may not be a situation where the parent and the state are supposed to be 50-50, and I don't agree that the parents have to come in at halfway, but they have to come in at least a little bit. They have to put forth effort and want to change. So unless there's any questions regarding active efforts, I'll just briefly touch on the issue regarding Dr. Weeks and the objection to her testimony. First, it's our position that Dr. Weeks was not presented as an expert. While she was an expert in her field, she was a fact witness in this case. She examined this first child when he was brought into the hospital, and her testimony was about her examination, what she saw. Additionally, the state never had her certified as an expert when she testified. Secondly, the civil discovery provisions, they don't automatically apply in a sync case because we have to balance child time with the rights of the parents. The time perception, as we all know, child time, the time perception of a child differs from that of an adult. And in sync cases, we have to take into account that expedited nature of the case to deal with permanency for these children. And the civil discovery provision does not take that into account. Additionally, the sync code contains a discovery provision in KSA 382245, which states after a hearing and a finding that discovery procedures will expedite the proceedings, the judge may allow discovery subject to limitations. So that could have been done if it had been requested by the parties, but it never was. And then that would have given the district court an opportunity to determine earlier on in the case, if those civil discovery provisions could have been followed in this case, but that was not made. But additionally, here, all of the parties were aware of Dr. Weeks. The parties were the same in the brothers' case as they were in this case. She was not a surprise witness. Everyone knew what the allegations were surrounding bringing E.L. into custody. And the parties also had the opportunity to cross-examine Dr. Weeks about her opinions and her observations. And so it's our position here, the district court did not abuse their discretion in allowing Dr. Weeks to testify in this case.
Ms. Coons, was the substance of the doctor's observations and testimony, was that pled in the petition?
I believe there's information, I would have to look, I don't recall specifically, but I believe there is information in the petition regarding what brought that first child into custody and was the basis for bringing E.L. into custody, the safety concerns. So I think that was in the petition.
Okay, thank you.
You're welcome. If there are no other questions.
Are there any other questions of the panel?
No.
No, I don't see any, Ms. Coons. Thank you for your argument. Mr. Brazil, ready for your rebuttal.
And I just kind of want to go through some of the topics that were addressed by the state. And the way the state fundamentally frames this is that father comes before this court asking you to reweigh evidence, which is improper. And I don't think that's what the request is. This is really no different than any other termination case where we're looking for some fundamental pieces to make sure we've terminated rights appropriately, that this parent is unfit, that that's likely to go for the foreseeable future, and that it's in the best interest of the child that rights be terminated. We have some additional requirements here of active efforts and some other findings under the Indian Child Welfare Act. This court passes judgment all the time on whether or not one of those pieces might be missing. This parent wasn't unfit. The foreseeable future wasn't there. It's a little different than just asking you to reweigh on the credibility of Dr. Weeks, say. It's look and see if the evidence presented at trial supports one of those critical pieces that was presented. And that's what Father asked this court to do, is say that critical piece of active efforts is missing here. And that warrants at least a remand to get some additional information. There's some discussion by the state about the case manager having reviewed or explained the importance of case plan orders. But I think that goes back to the guidance from the BIA guidelines. It says it's different than coordinating care for somebody. It's also actively assisting or facilitating visits to get there. You can explain till the cows come home, but if you don't do that secondary part of actively assisting, it is fundamentally a passive or a reasonable effort. There's a distinction between those two things. And then this question about transportation and saying father got to his job, he got other places. I don't know necessarily that that excuses the state when trying to remove a fundamental right from somebody of not extending a courtesy of transportation somewhere else. Whatever the reason, if he can't get to substance abuse treatment, but he can get other places, your remedy is provide transportation to substance abuse treatment. That should be the goal. A person having transportation in one instance doesn't excuse the state from doing its duty under the statute. You know, the bottom line of what we're looking for, and one other item on visitation quality, both DCF policy and the Indian Child Welfare Act suggest that these things should be done in the most natural setting possible. I realize that has some very significant limitations when we're dealing with a global pandemic, but all of this kind of goes back to the fundamental question here is, why was termination at this point appropriate? I know we have questions of child time. I know there are considerations of getting permanency quickly, but it just seems very premature to say we should proceed to termination when the best evidence indicates waiting a little while would have provided us the evidence we needed to truly judge whether there was secondary change or whether or not termination of these folks'
Well,
rights
excuse
were
me.
appropriate.
How do you know that in a little while we would have had the evidence, considering from the inception of the case to the time of termination, neither parent had made any progress on this ultimate issue of the abuse?
Well, so this child wasn't subject to abuse. In a review of the petition
Doesn't
in this
make any
case,
difference.
well, it does, because there's a fundamental difference between this case and DL. DL was inherently a physical abuse case. EL, if you review the petition, it was mom has issues taking care of child in hospital regarding feedings. There's concerns of attentiveness in the hospital. Dad's not around in the hospital. Oh, by the way, there's a sibling in care because of injuries.
No, you've
So
got a
it's two
kid with
pieces.
massive injuries and no explanation how it handled and no acceptance of responsibility. My question really goes to, you say if you got a little bit more time, we're going to know. How are you going to know when the months preceding, there's been no progress made?
That's a fair point. And that's ultimately a question I would say is to foreseeable future is, can we judge based on past conduct, what we have? And I don't know the answer to that. I don't. But in a situation like this, where we've got a fundamental right at stake, I would suggest the court should err on the side of caution rather than just presume it's a foregone conclusion when there are other areas that are deficient. And if there's no other questions, I will yield the rest of my time. Thank you.
All right.
Thank you, Mr. Brazil. Thank you, Ms. Kuhn. We appreciate your arguments and we take this case under advisement. This court will be adjourned.